see that the state has waived oral argument, so you will have 15 minutes to present oral argument. We have the briefs, and we're ready to when you are.
Thank you very much, Your Honor. May it please the court. Good morning. I'm Jacqueline Corgan, and I represent the appellant in this matter, Mr. Robert Kolvek. Just as in the previous case, Mr. Kovek has a consolidated appeal. This one involves 5 separate case numbers because Mr. Kovek was sentenced on 5 different case numbers in this particular case. He was tried based on allegations in 2 indictments, one from April of 2015 and one from May of 2015, and then he was also sentenced for community control violations and essentially violations of judicial release in 3 previous cases. So they all had to be brought separately, separate numbers, and lumped in together for Your Honor's consideration this morning. But concerning the April 2015 indictment, which is the most serious of the cases because it involves 3 charges in connection with manufacturing, possession, and assembling of chemicals for the manufacturing of methamphetamine. Mr. Kolvek raises 2 challenges to that particular indictment, or actually that particular case. First, that the indictment in the case was duplicitous, and then also that the indictment was multiplicitous. These are 2 separate concepts, and that's why there are 2 separate assignments of error.
Now we have 2 separate assignments here just to say the words.
Indeed. But an indictment is duplicitous and can offend due process when you have 2 or more separate offenses that are charged in the same count. And the difference is with the next assignment of error that an indictment can be multiplicitous when you have more than 1 count charging the same conduct. And that's more of an allied offenses type of assignment. But concerning the first assignment of error, that this indictment was duplicitous, and therefore Mr. Kolvek's convictions from the April 2015 case need to be vacated. The problem arises when you have an indictment that, like I said, charges 2 or more separate offenses in the same count because it can be unfairly unclear. Because remember, we have to have a sufficient indictment in order to properly meet the demands of due process.
Is there no way to cure that due process issue through the course of the proceedings? The state maintains that in the record we're going to find discussions on the record about what the case is going to attempt to approve in terms of time and place and behavior.
And if I could add on to that, at the point of the trial, if there was not the opportunity to prepare, because maybe what the state said, the information wasn't as fully contained in the discovery, wouldn't a motion to continue have remedied the situation? Go ahead, Judge Hensels, I'm sorry.
So I think it's basically the same question. Do you need to show prejudice, and it's because it's a due process argument?
I don't believe we do, Your Honor. I think we just have to show that it's not clear which one of any of the alternative sets of facts upon which my client could have been convicted for 1 count. Just to show the vagueness, essentially, would show, I guess, prejudice, if that's what Your Honor is looking for.
I didn't mean to misspeak, Judge.
No.
Perhaps it wasn't just the same question.
They were close enough.
But also to segue to Judge Callahan's question, and I think maybe this will help clear it up too, is that if I'm recalling the record correctly, there may have been a motion to continue by Mr. Kolvek's counsel, the one he obtained just prior to trial. And that motion in this case was denied. Sometimes that could be the cure of it. Usually, the cure for this kind of error is to request a written bill of particulars. And in this case, Mr. Kolvek's trial counsel didn't request one, but when Mr. Kolvek had previously been between counsel, when he had no counsel at all, he made his own separate motion for a bill of particulars. But since I did put in my brief that I'm probably going to have to ask you to notice this assignment for plain error because no actual written request for a bill of particulars was ever filed by anybody with an actual license to practice law in this case. It was just an oral request by Mr. Kolvek himself. So normally, that's the cure for this, is to request a bill of particulars, find out from the state exactly which set of facts it intends to use to prove each charge. But by the time we got through this case, at the end of the day, and even at the end of the case, the instruction to the jury and the closing argument on behalf of the state was, jurors, you can pick whichever set of facts that you like to convict Mr. Kolvek for these offenses. Well, I take that back, for counts 2 and 3, because on count 1, the state told the jury clearly it has to be at location A, the Archwood Avenue location, where there were actually children who were living at the premises. Regarding counts 2 and 3, however, the jurors could choose, said the state, between activities at Archwood Avenue or activities at Stanley Avenue. And it's unclear from the record, because we can't see into the minds of the jurors, which one they thought collectively supported the conviction, or maybe the jury wasn't even unanimous as to which location may have supported the conviction. And in fact, the jurors did send a question back to the court about that very thing, and they got essentially the same answer. You can pick between either one. But it's that makes this particular case unclear enough to have violated due process for Mr. Kolvek, because we do have a situation where it's not clear whether the jury was unanimous as to which set of facts, and clearly if the state had chosen to, it could have indicted Mr. Kolvek for separate charges for each one of these locations, because as I mentioned, and this dovetails with the multiplicity argument that he has, that had these been charged separately, they would not have merged for purposes of sentencing. Each location is not an allied offense of each other. So possession of chemicals at Archwood Avenue, because it's a separate location, separate animus, separate acts, is not probably going to merge with an assembly of chemicals at Stanley Avenue. And so when you have offenses that would not merge for sentencing, it doesn't seem logical to say that they should support the same guilty finding. So that's how those two dovetail. So my argument is that these were separate offenses indeed, charged in the same count. And because we don't have that clarity, that offends due process and requires a vacation of Mr. Kolvek's convictions on counts 2 and 3.
Under the plain error analysis, would we have to, in order to sustain the assignment of error, would we have to, and the allied offense, it's weaving back together that part back there.
Yes.
Would we have to find that there was insufficient evidence as to at least one of the counts? Because otherwise, aren't we just speculating as to what the jury did when they made its findings?
No, I haven't seen that in any of the precedents that you would have to find there was insufficient evidence.
Because under plain error, you have to say that there was not a fair trial by virtue of error, that the outcome would have been different, right?
I do understand that, but I don't read that as requiring an insufficiency finding as to either of those fact scenarios.
Since I kind of joinder. Can we talk about that joinder, assignment of error?
Certainly.
I appreciate that, because the state comes back with, well, it's all the same evidence, so what, it's the same drugs, it's the same activity, and I'm trying hard to figure out how you pull that back apart from how the evidence and how the jury was instructed in this case, because that comes right from your statement that we don't know what he could have been convicted on having drugs here and not here, because the possession and the assembly, the 2 and 3. So can you walk me through the joinder argument that you're making so I can understand what your argument is?
Sure. And I'm hoping I'm getting your question right.
Yeah, it was long, so.
Well, I think the difference between my position and my client's position, actually, and the state's position is that the state's position is essentially it doesn't matter. And the position of my client is due process always matters. And so we always have to be clear to satisfy due process. We can't, the law does not permit us to assume these things. We have to know. And when we have this lack of clarity, it does matter. The state's argument is it's all drugs, so it doesn't matter. It does matter. It would matter if, for instance, the state had chosen to indict my client for the same offenses for each location. In other words, one charge of manufacturing methamphetamine for Archwood Avenue, one charge each of assembling chemicals for Archwood, a charge of assembling chemicals for Stanley Avenue, and possession of meth at Stanley Avenue, and possession of meth at Archwood. Those could all technically have been indicted and would not have merged for purposes of sentencing.
And so your argument in that regard is joinder of those 2 separate alleged acts versus joinder of the folks because didn't they join the Stanley Avenue defendants in one case, or was your client's case separate and apart from the other charges that came out of that activity?
Well, that's part of what made all of this very confusing for my client to adequately prepare a defense, was that he and the Stanley Avenue defendants were all charged together on the same indictment.
And tried together?
They were not tried together. The other 2 entered guilty pleas, but how the indictment was written was my client and the other ones were defendants B, C, and D. And later, the actual resident of Archwood Avenue was indicted separately under the same case number as defendant A, and she actually was indicted for different counts. So it was a very strange and confusing set of facts.
But not tried, no one was tried.
No one was tried together. The other 3 each pleaded guilty. I would, because I understand I'm probably running low on time, I do want to very briefly address assignment of error number 5, just for the purposes of conceding that one, based on the authority of State versus Moreland, which this court pronounced after the briefs were submitted in this case. And assignment of error number 5 is virtually identical to the assignment of error in that case. And so I submit that one to your honors. However, if I do have a moment or 2 left.
You have a minute.
I have a minute, okay. My actual joinder assignment of error was assignment of error, I believe, number 3 or 4. 3. And that dealt with the improper joinder of the April and May indictments. What I would like to say on that is that the May indictment involved the purchase of pseudoephedrine, which was an assembly of chemicals, and the only reason I bring that up is that trying these 2 indictments together, even though the state's argument would be, well, they're all trying to get drugs, is that, yes, it still matters, because trying these together makes it more likely that a jury would see that, or would believe that my my client had a propensity to commit this kind of conduct. But I understand I have probably less than a minute left now, and so knowing that, I would respectfully ask this court to vacate my client's convictions on counts 2 and 3, and at least, given also the confusion on count 1 as to where it was going to be, and to reverse my client's convictions. Thank you very much.
Thank you. Thank you for your presentation today. Court will take the matter under advisement, issue a written decision which